It's this statement that has changed what is happening today. I'll read this statement to you. I, Stephen Lennon, journalist of an address in Luton, will say as follows. This is a bit of a long statement, so just bear with me. Share this, share it wide. Louis, get your face in there, little man. I am the defendant in these contempt proceedings, and the court has served me with 2 allegations of contempt. This is one more than I faced at the Crown Court of Leeds. In relation to the first allegation, breaching the order of the court, which requires, as I understand, an intention to interfere with the administration of justice, I would like to say this. Firstly, I would like to assure the court that undermining the court's authority or interfering with the administration of justice was never my intention. I believed I acted in good faith within the parameters of the Section 4 reporting restriction in place. The information I provided was in the public domain. It was factual and relevant, but did not provide any details of the trial's proceedings other than what had already been reported previously and was readily available online. I rely on the documents in my bundle as examples of what had previously been reported. When I arrived at Leeds Crown Court, and I hope the media are going to actually print this. When I arrived at Leeds Crown Court that morning, I could not obtain any specific details of the reporting restriction order. I do not believe there is a website which holds such details. So I researched online and I reviewed the reporting restriction guidelines provided. They state that the court should include details of reporting restrictions on the court listings, both online and in court, and also provide a notice on the door of the court. My solicitors have photographic evidence to show that the court did not follow these guidelines that day. There were no details listed anywhere of a reporting restriction for this case. This is also in the bundle. The only time the notification about reporting restrictions was available was later that afternoon after the court had convicted me and sent me to prison. Only then did the court follow the guidelines and list a reporting restriction against the court listings for both the grooming case, the Islamic rape jihad case, and my subsequent case. After my previous experience with contempt of court in Canterbury, I went out of my way to ensure that I would not fall foul of the law again. I privately paid for training with one of London's leading law firms, Kingsley Napoli, to cover all details regarding contempt of court. There is a documentation in relation to this in my bundle. On that morning at Leeds Crown Court, I had knowledge of the verdicts of the first phase of the trial. I knew many of the specific details discussed in court for this particular trial. I did not talk about these in my live stream on that day. I had understood, based on my training, that the specifics of the case and the verdicts were off limits for reporting restrictions. Drink. Having... Thank you, man. Having been unable to obtain any details from the court on the conditions of the reporting restriction, I decided to review the guidelines for reporting restrictions. On the judiciary's website, there is a practical guide aimed at judges and the media on the statutory and common law principles that should be applied with regards to reporting restrictions. This paper was called Reporting Restrictions in the Criminal Courts Act. In this paper, it states, the court have no power under section 4.2 of the Contempt of Court Act to prevent publication of material that is already in the public domain. See page 27 of this document. I followed my training and this guidance to the letter. I did not divulge any of the previous case verdicts. I did not detail any specifics mentioned in the trial. I did not assume guilt. I refrained from entering court property. I even asked the officer outside court where the court boundaries were and was I okay to film, which he replied and confirmed I was. I also followed the guidance document issued on the judiciary website informing me that I could only reference information that was already in the public domain. Every single thing I said that day was in the public domain. I actually read the charges and the names of the defendants from a BBC News article, which to this day is still live on their website. I also made sure not to film anyone other than the defendants. I was calm and respectful throughout. It is my understanding that there is no individual in the last 60 years that has been sentenced to prison for a publication breach of a reporting order. It would appear that my punishment is exceptional. I would ask that I am treated in the same manner as every other journalist who has been charged with these allegations. The journalist Rod Liddell was writing for the Spectator magazine in relation to the Stephen Lawrence murder trial when he was sentenced for breaching a Section 4 order and risking prejudice to the trial. He was given a fine. Journalists at the Daily Mail and the Daily Mirror published highly prejudicial material on the trial of Levi Belfield, who abducted and murdered an 11-year-old child. This contempt of court led to the collapse of the entire case and the discharge of the jury. It robbed one of the victims of the chance of justice. The reporters in this instance were not prosecuted. Instead, their employers were found guilty of contempt and fined £10,000. The Daily Mirror have run hit piece after hit piece after hit piece against me for this crime when they have committed far worse in the history. I have reviewed the court transcripts from Leeds Crown Court, where the judge was discussing various reporting order breaches. The judge and the CPS discussed the fact that multiple news sources breached the very same order placed on my trial, and some breaching both the reporting orders by mentioning the grooming trial as well as my arrest and prison term. Lizzie Dearden, hello Lizzie, you're here somewhere, the Home Office Affairs correspondent at The Independent, actually refused to remove her article when provided with the order stating that the effect of social media voids reporting restrictions. The CPS and the judge agreed that these breaches of the order were a matter for the Attorney General to review. When I was informed of the blanket order, I offered to delete my video immediately. Despite the multiple breaches of the order by different newspapers that weekend and the flat-out refusal by Lizzie Dearden to take her article down, not one of these journalists or the editors of those publications have ever been arrested or prosecuted for breaching Section 4.2 of the Contempt of Court Act. According to the court transcripts, the newspaper breaches of the reporting order was a matter for the Attorney General. My case was not referred to the Attorney General for review. Instead, I was hauled into court immediately, refused my own choice of legal representation, prosecuted and convicted in a matter of minutes in what the Court of Appeal regarded as a flawed trial. I was then imprisoned for over 2.5 months in solitary confinement until I won the appeal. I was held against my categorisation, moved to the highest Muslim population Cat C prison in Britain, subjected to mental torture and constant threats and abuse, and had all of my rights removed in the interests of prison safety. It is clear to me that my continued persecution and heavy-handed tactics from the state is because of who I am rather than what I did. In relation to the second allegation, the strict liability allegation, I would like to say this. It is only since my original trial that there has been an additional charge added, suggesting that the contents of my live stream were prejudicial to this case. The case completed, the jury concluded, and the verdicts were given. I would like to state clearly that in the transcripts from the original trial, the judge discussed my video with Mr. Wright QC, Prosecution Counsel. Having reviewed the entire content of my video, Mr. Wright stated in court, and I'll quote, "There is nothing they could have seen that could in any way prejudice them against the defendants." Judge Marson agreed on the record in court. For this reason, I cannot see why I should face 2 charges when the core of the allegation in front of Judge Marson was the breach of the Section 4.2 order, other than because I am regarded as a political activist and the charges are motivated by my political activism. I do not accept that the material that was live streamed created either a real or substantial risk of prejudice to the Leeds proceedings. The prosecution counsel and the judge both agreed on the court transcripts that my live stream could not have prejudiced the jury. Will the media please report that? In fact, we don't need the media to report that because we are the media. Everything I reported that morning was fair and accurate, published in good faith within the constraints of the judiciary's guidelines for the media. I will address each point in the allegations drafted by the advocate of the court. The first allegation is that I suggested the defendants were involved in wider criminal activity. This is not correct. I was referring to 2 reports, one on the radio and one in the Huddersfield Examiner, which set out the allegations relating to the 29 individuals. The second allegation is that stating that those of the same ethnicity and religion as the defendants were disproportionately likely to commit the crimes for which the defendants were being tried could prejudice the trial. This statement is factually correct. The Quilliam Foundation, who are a Muslim-run anti-extremism think tank, have produced a research paper looking at convictions of these street grooming from 2005 to 2017. This is in the defence bundle. They found 84% of all convictions were South Asian, with the significant majority of those being Pakistani Muslim. All of these victims were white children. Sajid Javid, the Home Secretary himself, announced on BBC News this year that in these types of street grooming, the individuals convicted are from a disproportionately Pakistani background. Nazir Afzal is the former head of the Crown Prosecution Service in the northwest of England. He's a lead prosecutor on child sexual abuse, and he also publicly stated on Channel 4 News that Asians, Muslims, and Pakistanis in particular are disproportionately involved in this type of street grooming. He also presented these facts in front of Parliament. I merely stated factual insight into the ethnicity and the religious makeup of the perpetrators of these crimes. I repeated publicly available research papers from the Quillian organisation, testimony from the former head of the Crown Prosecution Service in the Northwest, and a statement from our Home Secretary himself, all three of which are in fact Pakistani Muslims themselves. I do not accept that reporting facts on the ethnicity or the makeup of a particular offender group could be categorised as contempt of court, given the number of grooming trials currently in progress across our country and the commentary on those facts which are widely discussed online and in the media. The third allegation, my voice is going, the third allegation is that highlighting as significant the sexual references of the abuse that I elicited from the defendants could prejudice the trial. I asked each of the defendants what their views were on the verdict they were expecting that day. All three of them separately made aggressive, vulgar, sexual references or sexual threats against both my mother and my wife. I did not ask the defendants to comment on their views on my wife or my mother. They did this out of the blue. Repeating what they actually said in the video has no relevance or prejudice on this trial itself. The fourth allegation in Britain in a court is that I made derogatory comments about the religious backgrounds of the defendants. I would like to point out I was not talking about specific defendants on trial. I was referring to a reaction I had received by family and friends on previous convicted grooming gangs. By derogatory comments, it appears to mean telling the truth that under Islamic law, the age of consent coincides with puberty. In Islam, there is no set age for marriage. The Islamic false prophet Muhammad, who is said to serve as a role model for every Muslim, is reported by Sunni Hadith sources to have married Aisha when she was 6 and raped her when she was 9. Mohammed was aged 56 years old at this time. The prosecution may not like to hear the truth, but there is no way that me sharing the truth and facts about a particular religion on social media can lead to prejudice on a trial. In relation to the fifth allegation, a number of comments relied on were made by other people. My comments related to grooming trials generally across the country rather than this particular case. E.g. the exchange at page 8 of the transcripts of the live stream relating to Rotherham and Oxford. I made it clear throughout my video that the trial concerned allegations. I made it clear that the defendants were innocent until proven guilty. I'm glad I've only got to do this once though. Hey. The nature and the number of these ongoing trials, prosecutions and investigations is highly alarming. I believe it is in the public's interest to hear the details and know of the complexities and the connections amongst the previous prosecutions. The future safety of vulnerable children at risk is my concern here, not the perceived prejudice towards the defendants because of their ethnicity or religion. If 29 Christian priests were on trial on such charges with reporting restrictions, I would feel exactly the same. When I initially went to Canterbury Court, I did so in what I felt was the public's interest. The police had DNA evidence on all 4 of the now convicted child rapists, yet the decision was made to grant these individuals bail. They were still running the same takeaway shop and coming into contact with young school children. One of the defendants absconded to Afghanistan. With DNA evidence on each of the now convicted child rapists, it is my belief that they should have been remanded to prison until trial in order to protect vulnerable children in the surrounding area.
We love you, Tommy!
Instead, a decision was made to release these paedophiles back into the community on bail. The same danger was placed on the children in case in question. The now convicted child gang rapists on trial in Leeds that day were also free to walk on the streets on bail. There were 18 different witness statements detailing the rape and the torture of those children, yet the justice system decided that they did not pose a risk to the British public and granted them bail. Yeah, just go. Just like the Canterbury case, one of these child rapists in Leeds also absconded before his verdict was reached. I believe he has fled to Pakistan, and according to the court transcripts, he was last seen leaving his house with a large bag. That is a convicted child rapist free to roam the streets because he was deemed no risk to the public, and Judge Marson granted him bail. Due to the reporting restrictions on the case, for the last 5 months, none of the British public have been allowed to be made aware that this man is on the run. When the reporting restrictions were lifted, how many national newspapers or news agencies have run with a picture of this man? Instead, they've run with headlines saying, "I risk letting them go free." I have previously been charged with a non-violent offence. I was remanded straight to prison to await trial. At Leeds Crown Court in May this year, the police whisked me from the streets. I was subjected to a fundamentally flawed trial, and then I was sent straight to prison within 5 hours. This is all whilst the very same system allows alleged child rapists with multiple prosecution witness statements and even DNA evidence implicating them to the crime to continue to walk our streets. The court has a duty to the victims and to the public to protect them, and telling them could help stop ongoing child sexual exploitation and maybe prevent future vulnerable children from falling victim to it. Again, I would like to reiterate that undermining the judge, the court, or the proceedings and the supremacy of the law of the administration of justice was never my intention. But I truly believe that the reporting restriction on this trial and subsequent connected trials are detrimental to the public and should never have been imposed, so the public could hear the details, use the full knowledge of the proceedings to help prevent cases like this coming before the courts. The jurors are given a responsibility. They are aware of the consequences of researching the cases they sit on. It should be upon them, and we should trust them to do the task with honesty and integrity. It should not be for the British public to be kept purposely in the dark just in case they do not. The contents of this witness statement are true and to the best of my knowledge and my belief. That was my statement that would have been read to the court. I would like to start off with some thank yous. Carson K, my solicitors. Richard Furlong, my barrister. My defence team, paid for by you. Have worked tirelessly behind the scenes, even for the last 24 hours with their submissions. What comes now, and this is where the intent on what they're doing. I have now come to this court 3 times. 3 times with my bag ready to go to prison. That's 3 times I've kissed my children and my wife goodbye. This political witch hunt must end now. The decision will now go to the Attorney General, and I hope he sees justice, sense. I am being told now that I may be back in court in 4 to 6 months. Now, that is how long it will take to bring another trial against me. I hope once the Attorney General reads my statement to the court, I hope they do the right thing and I can get on with my life and make plans for the future. I do believe that with this support, with the support that's been shown, that the Attorney General will kick this into the long grass. I want to just say again,
we love you. We love you. We love you.
I want to say that you all did get me free. All of you got me free. I also want to say that I'm going to try and say it anyway. I had this problem last night, an emotional mess. But I want to say that when I come out of prison, I wasn't in a great place, but I've come on recovery and everyone's given me so much support and time. I want to thank you as well from my family. I want to thank every single person who showed me support. When I come out, my head was all over the place and I couldn't even deal with the solicitors. Ezra. Love you, Ezra. We do. Love you, Ezra. We do. We love you, Ezra. We do. Oh, Ezra, we love you. We love you. I want to thank today. When I was sitting in prison, I read a newspaper article, and it was an interview with a representative of the Middle East Forum in America. It's an organisation headed by Daniel Pipes, and in that article, I read, "We will not stop until Tommy Robinson is free." I would like to thank personally Daniel Pipes, everyone at the Middle East Forum. The stage I'm standing on now, the PA system I'm speaking on, was supported and funded today by the Middle East Forum in America. The entire campaign to free Tommy was supported by the Middle East Forum in America. And I want to embarrass Lisa if she's here from the Middle East Forum. And The Middle East Forum representative is here. Thank you. And take the message back to America that the British public love Donald Trump. And we love America. Also, there are other people who until I got out of prison, I had never personally met. People that took my cause on. Jared Batten, UKIP. Jared, along with the most hip, cool, older gentleman I've ever known in my life, which is Lord Pearson. They worked for my safety, to make sure I was safe during my imprisonment. I want to say that's a personal thank you, Jared, to UKIP, to everyone, to Lord Pearson. Janice Atkinson as well, who I only had the pleasure to meet last week. Janice took up my fight as well, and again, this was Avi. I've only met. There's so many people that I've only had the chance to meet since getting free. Avi. And I know somewhere. I don't know where she's gone, but Anne-Marie Waters. And so thank you to Anne-Marie Waters, darling. Thank you for the support as well, babe. Free Melanie Shaw. Free Melanie Shaw.